Sir, it's from quota number 6. Is voice clear? Venkatesh Bhagat, sir. Venkatesh Bhagat, sir. So first there will be sufficient to VP. But there will be sufficient to VC if you got an adjournment. After presentation, the memo request, is made through microphone. And after memo request, the adjournment request.
Any mentioning through video? Any memos? Mentioning
Serial
from left side. 40? Yes. 46? Yes. Request of the legal counsel for the petitioner, a week's time is period is granted. Yes. Yes. One week. Yes, finally. Yes. Request of the legal counsel for the petitioner, a week's time is period is granted. Yes. Yes. Same order, 1 week. Yes.
45 minutes. Weeks time, there is an element of settlement. Petitions.
Petitioner, 1 week. Yes. 40? 47. One week. Yes. 40? 40. One week. Yes. Yes. Petitioner, 1 week. Yes.
Serial number 51, please.
Yes.
I request 1 week time.
One week. Finally. Yes.
It will be called.
Yes.
Serial number 38, my lords.
Yes.
1 week time.
Serial number 1.
My lords,
38.
38, my lords.
One week. Yes.
My lords, serial number 34,
Yes.
appearing for the petitioner in this matter.
Yes.
In fact, on the last occasion, my lord, there was a direction by this honorable court
Hmm.
to put up this matter after the disposal of the MFA.
Hmm.
The MFA is still pending, my lord. Interim order is operating against the very same order. So it can be taken up somewhere after 1 week, my lord.
You are for?
Petitioner,
Petitioner, 1 week. Yes.
public.
40? What the matter is about? Whether from an injunction order, writ petition lies here?
Court has reversed the
Request of the petitioner, 1 week. Yes. Call the cases.
Serial number
Non-compliance of office objection. First time. Serial number 1. Tata Shetty.
appearing to the petitioner in this matter was not filing a memo for withdrawal. It will be posted in a day or two. We'll file the memo with the petitioners. With the
You are
parties.
filing a memo.
Yes, madam.
Are you representing in serial number 1?
Yes, I'm representing for serial number 1 for the
You
petition.
are filing memo right now or you want to
I'm
pass over to?
filing a memo on behalf of the advocate, my lord. The party signature, he's traveling, I'm not able to get it. If it will be posted in a week's time, I will.
Party signature is not required for you to withdraw.
Apologies, my lord. I'll be filing a memo.
File it right now. Yes, ma'am. Sir. Land counsel for the petitioner who is physically present files a memo seeking withdrawal of this petitioner as not pressed. In view of the memo supporting submission, the petition stands dismissed as not pressed. Yes.
Serial number, second time, serial number 2. 14 तारीख.
For weeks time to comply with the office.
The
Office has
request of the land counsel for the petitioner as finally a week's time is granted to come.
Third time. Serial number 3. Abu Bakar Shafi.
Request of the learned counsel for the petitioner as a final last chance, a week's time is granted to comply of his objection. However, by imposing a cost of ₹500 payable by the appellant to the legal services committee of this court within 2 days from today and filing the complex form, etc., etc. In case if the cost is not paid and office objections are not complied within a week from today, the court may proceed to pass appropriate order, including dismissal of the petition for non-compliance of office objection. List the matter on 1-2. Yes.
Till number 4, Sachin RR.
One of your password is
Till number 5, Shauri HR.
However, subsequently, there are 2 more objections have been raised. I completed in a week's time.
considering the submission made by the learned counsel for the petitioner that the office objections due for complaints are either subsequent to complaints of the previous office objections, and finally a week's time as period is granted to comply office.
Till number 6, Dr. S. Armugam.
Similar to serial 3, ₹500 cost within 2 days. Yes.
Till number 7, Maruti S. Till number 8, CM Nagabhushana.
None of your password.
Till number 9, S. Naveen Kumar.
None of your password.
Till number 10, Ventesh R. Bhagat.
My lord, in this case, defendant number 3 is not made as a party in this writ petition. If a rejection, the application was filed to withdraw the suit with a liberty that has been challenged by the defendant number 1, 2, 4, and 5, LS of 5. That's the office objection is that defendant number 3 is not made as a party, my lord, to this writ petition. For that, counsel's notice.
Defendant number 3 was a party in the original suit, right?
Yes, well.
Arraign him as a party, taking the notice would be at your discretion.
Much obliged. I will take.
Or the submission of learned counsel for the petitioner on the office objection. Since the defendant number 3 was a party in the original suit, against whom the petitioner, if has not claimed any relief, may seek dispensation of notice, however, at his risk, he is still required to arraign him as a party. As such, office objection sustained. Finally, a week's time is granted to comply office objection.
Much obliged.
Last chance.
5th time, non-compliance till number 11, G. Balkrishna Shastri.
Wait for a week's time. Comply with all the.
What is the office objection that is due for complaints now?
The deed does not tally.
How do you comply that?
Plus, Kumar, we have. Because like.
Now, how do you comply office objection? For that, why a week time is required? You can do it in under 10 minutes. Counsel for the, at the request of the counsel for the petitioner, matter is passed over to enable him to report the complaints of office objection immediately. Failing which, the court may proceed to pass appropriate order when the matter is taken up in the second round.
Number 12, Ganapati Subraya Bhatt.
If you do it in the forenoon session, 200 rupees cost. If you want to do it during the course of the day, 500 rupees cost. Which one you choose?
I'll do.
In the forenoon session. Imposing a cost of rupees 200 payable by the petitioner to the legal services committee of this court. Forthwith, the petitioner is permitted to comply the office objection before the closure of forenoon session in the registry. Failing which, the court may proceed to pass appropriate order. The petitioner before complaints of office objection to file the memo paying of cost along with the original receipt in the registry. Call the matter at 2:30 p.m.
Number 13, now Ramesha, any?
Another 3,000 rupees cost. ನಿಮಗೆ ಗೊತ್ತಿದೆ ಯಾಕೆ ಅಂತ. ಅಷ್ಟೇ. Counsel for the petitioner fairly concedes that he has not paid the cost of rupees 2,000 ordered by this court on 10/11/2023. Admittedly, all the office objections, which are 8 in number, also have not remained unattended by the petitioner. Under the said circumstance, though the petition could have been dismissed for non-compliance of office objection and recovery of the cost could have been ordered, however, considering the submission made today by the learned counsel for the petitioner, imposing an additional cost of rupees 1,000 payable by him to the legal services committee of this court forthwith and filing a complaints memo along with so and so, he is permitted to pay the cost ordered on 10/11/2023 in the forenoon session and comply the office objection in the registry during the course of the day. Registry to permit only after ensuring the payment of all the costs due for payment by him. In case if the office objections are not complied within time, registry to list this matter. On 29/1.
Number 14, Keshav R. Agnihotri.
The office objection mainly is the striking of the annexure F. My submission is regarding annexure F, Lord. The relevant portion which is challenged is at page number 29. So the other, it is only order sheet. In the order sheet, the order is passed. So my submission is the other earlier portions. They are only.
Now, what is that cancellation mark? What submission you have made?
Yes, sir.
Now, what is your submission with respect to the office objection?
Regarding that, Lord, the portion challenged is 14/6/22, page number 29. So other portions are only the dates, Lord, regular dates are given, and the portion which is challenged under this state petition is page number 29.
No, why did you cancel that?
Otherwise,
You are not supposed to, that amounts to tampering of a document.
yes,
That amounts to tampering of a document. You ought not to have done that.
please.
Maybe the document may be 1,000 pages. And the relevant portion which you are challenged may be in one particular page in 3 sentences. It doesn't mean that remaining 999 pages, you are entitled to cancel it.
Yes.
When it is a part and parcel of the very same document, it has to be retained intact. Or you should have obtained the certified copy of that particular date only. Date only. So option was yours. You have chosen to produce the entire order sheet. Then after obtaining the entire order sheet, suffice for you to say that impugned order, if the order dated so and so. Yes, you would have seen that.
Typed copy of relevant portion. it is typed copy itself, so I
Your
thought.
question is, you are not supposed to cancel it.
Wait,
It has amounted for tampering.
wait.
Yes. What is the submission now?
Only relevant, I thought, because the office will ask the typed portion of all the dates, I thought of. Because it was not relevant, and only concerned portion was 14/6/22, I thought of. Doing that, it was a mistake on my part. I should not have done it.
Yes, you shouldn't have done it.
Please.
What do you intend to do now?
Only that office petition is remaining, Lord. The portion which is now under challenge is 46/22, now it is typed copy. So that
There
may
is
be
counsel for the appellant even after getting convinced himself that he ought not to have cancelled. The other portion of the orders in Annexure F, except the one which he claims to have challenged in this writ petition, the same would result in tampering of the document, still maintains that as a particular days or the particular dates order which is challenged in this writ petition having not been cancelled, the same be accepted. Next line, the above submission that the uncancelled portion can be accepted is not acceptable for the reason that the very preliminary act of cancelling the other portions of certified copy, even according to him, has resulted in tampering of the document. As such, the petitioner is required to furnish a fresh certified copy of Annexure F, or that particular day's certified copy, which according to him is required to be challenged in the writ petition. Since the petitioner hitherto has not done the same, but was granted with adjournments of not less than 5 times, there's no point in granting any further time. I am dismissing it now.
I produced my submission, I thought it was a wrong thing done by me. I will furnish the, otherwise I will furnish the typed copy of all the entire portion.
ನೀವೀಗ ಇಷ್ಟೊತ್ತು ಅದನ್ನ ಹೇಳಿದ್ದಕ್ಕೆ ನಾನು ಇಷ್ಟುದ್ದ ಬರ್ಸಿರೋದು, ಈಗ ಡಿಸ್ಮಿಸಿಂಗ್ ಹೊರಟಿರೋದು. ಅಷ್ಟಾದ್ರೂ ನೀವು ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ನೀವು ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಿ ಟೈಪ್ಡ್ ಕಾಪಿ ಆಫ್ ದಿ ಅದರ್ ಆರ್ಡರ್ ಆರ್ ಐ ಫೈಲ್ ದಿ ಟೈಪ್ಡ್ ಕಾಪಿ ಆಫ್ ದಿ ಅದರ್ ಡೀಟೇಲ್ಸ್ ಆರ್ಡರ್ ಅಂತ.
Entire order sheet I will produce.
ನನಗೆ ಆಶ್ಚರ್ಯ ಆಗ್ತದೆ. 33 ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದ್ದೀರಿ. ಇದು ಅತ್ಯಂತ ಸಣ್ಣ ವಿಷಯ.
I will file the, my submission is, I will file the typed copy of all the order sheet, entire order sheet.
ಸರ್, ನೀವು ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕೋದು ನಾನ್ ಕಾನ್ಸೆಕ್ವೆನ್ಷಿಯಲ್, ದಟ್ ಈಸ್ ಆಫ್ ಇನ್ಕಾನ್ಸೆಕ್ವೆನ್ಸ್. Typed copy is enabled to read what in the manuscript copy is, when the original manuscript copy itself is striked out or cancelled. The typed copy doesn't sail on its own independent of the original copy. ಇದೆಲ್ಲ ಬೇಸಿಕ್ ಥಿಂಗು. ಆದ್ರೂ ಏನೊಂದು ಪ್ರಯತ್ನ ಮಾಡುದು, ಕೋರ್ಟ್ನ ಹೇಳದನ್ನ ಹೇಳೋದು, ಸಮಯ ನೋಡೋದು. ಈಗ 2 ಆಪ್ಷನ್ ಇದೆ. ಸೆಂಟೆನ್ಸ್ ಅರ್ಧಕ್ಕೆ ನಿಂತಿದೆ. ಒಂದು ಡಿಸ್ಮಿಸ್ಸು ಅಥವಾ adjournment by a week with a cost of 1,000 rupees. Which one you prefer?
For each time.
As such, granting any further time even as a last choice would be only on cost. Accordingly, imposing a cost of rupees 1,000 payable by the petitioner to the Legal Services Committee of this court within 4 days from today and filing a complaint form, etc., as a ultimate opportunity. 10 days time is granted to comply of this objection. Yes.
6th time till number
Lord,
15.
only that portion is required.
ಅದು ನೀವು ಡಿಸೈಡ್ ಮಾಡಬೇಕು, ಕೋರ್ಟ್ ಅಲ್ಲ. ಯು ಆರ್ ದ ಅಡ್ವೊಕೇಟ್. ಐ ಕೆನಾಟ್ ಅಡ್ವೈಸ್ ಯು ಬೈ ಸಿಟಿಂಗ್ ಹಿಯರ್. ನೀವು ಹಾಕ್ಬೇಕಾಗಿರೋದು ಯಾವ ಡೇಟಿನ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಿ, ಆ ಡೇಟಿನದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಫ್ ದಿ ಆರ್ಡರ್ ಅಷ್ಟೇ ಹಾಕಿದ್ರು ಸಾಕಿತ್ತು. ನೀವು ಅದ್ರ ಹಿಂದೆ ಮುಂದೆ ಎಲ್ಲ ಬೇರೆದನ್ನೆಲ್ಲ ಸೇರಿಸಿ ಹಾಕಿದ್ದೆ ಸಮಸ್ಯೆಗೆ ಮೂಲ. ಹಾಕಿ ಸುಮ್ಮನೆ ಇದ್ರು ಆಗ್ತಿತ್ತು. ಹಾಕಿ ಅದ್ರ ಮೇಲೆ ಅದನ್ನೆಲ್ಲ ಉಳಿದೆಲ್ಲದನ್ನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದಿರಿ. ಆ ರಂಗೋಲೆ ಬೇಡಿತ್ತು. ಯಾಕೆ ಅಂದ್ರೆ ಒಂದ್ಸತಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇಶ್ಯೂ ಮಾಡಿದ್ರ ಮೇಲೆ ಅದು ಯಾವ ರೀತಿ ಇಶ್ಯೂ ಆಗಿದೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ, ಅದೇ ರೀತಿಯೇ ಅದು ಮುಂದುವರಿಬೇಕೇ ಹೊರತು ಅದರಲ್ಲಿ ನೀವೇನು ಬದಲಾವಣೆ ಮಾಡ್ಲಿಕ್ಕಾಗಲ್ಲ. ದೋ ವಿತ್ ಎ ಗುಡ್ ಇಂಟೆನ್ಷನ್ ಟು help the court to identify which particular day's order. Intention goes to background. Act comes to foreground. Act is not permissible. Therefore, intention become insignificant, non-consequential. ಈಗ ನಾ ಕಾಸ್ಟ್ ಜಾಸ್ತಿ ಮಾಡ್ಬೇಕಲ್ವ, ಜಾಸ್ತಿ ಹೇಳಿದೆ ಬೇಡ, ಅಷ್ಟೇ ಇರಲಿ. ಯಾವ್ದು ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ತಿದ್ದೀರಿ ಆ ಡೇಟ್ ಅನ್ನೋದು ಆರ್ಡರ್ ಆಗಿ ವಿತ್ ದಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಆಫ್ ದಿ ಪಾರ್ಟಿ.
Sixth time non-compliance, serial number 15, Jagadish HT.
ನನ್ನ ಪೇಪರ್ಸ್
Orders matter serial number 16, Vivek Holla.
petitioner. ನೋಡಿ ಹೇಳಿ. Yes.
Serial number 20, Prithvi Wadayar.
Yes.
Take a first step, allowed fresh address to the point of the.
At the request of the counsel for the petitioner. 4 days time is granted to ascertain the correct, complete and present address of answered respondent number 3 and to take first steps to ensure the service of emergency notice upon him. Yes.
Serial number 21, Chandrasekhar Reddy.
The land counsel for the petitioner is neither present physically nor through video conference. This the matter after 2 weeks. ಬೇರೆ ಲಾಯರ್ನ ಕರ್ಕೊಂಡು ಬನ್ನಿ ಅಮ್ಮ 2 ವಾರ ಟೈಮ್ ಇದೆ.
Serial number 22, Nagendra Nayakar.
All the steps are taken.
Counsel for the petitioner submission needs to run registry to verify and proceed.
Serial number 23, Basavayasi.
Then after finally a week's time is granted to take steps. Otherwise, the court will proceed to pass appropriate order.
Serial number 24, Shanmugappa.
Matter would be passed over by the process and report, otherwise it would be dismissed. Withdraw right now. What is not required? Say it was you who made on 2 previous occasions submission. I myself have granted you the adjournment. Yes. So if you are intending to withdraw, withdraw. Absolutely not. Absolutely not. ನಿಮಗೆ ಸಾಕಷ್ಟು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೇನೆ, ನಾನೇ ಕೊಟ್ಟಿದ್ದೇನೆ ಸಾಕಷ್ಟು. ಬೇಡ, ಅದಕ್ಕೆ ಮಾಡಿ. ವಿಡ್ರಾ ಮಾಡಿ ನಿಮಗೆ ಕಂಪಲ್ಷನ್ ಇಲ್ಲ. ನಾನು ಹೇಳಿದ ನಿಮಗೆ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳಿ ಅಂತ, ನೀವಿಲ್ಲ ವಿಡ್ರಾ ಮಾಡ್ತಿದ್ದೀನಿ ಅಂತೀರಿ, ಮಾಡಿ. ಮ್ಯಾಟರ್ ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೇನೆ. ಇನ್ನೊಂದು ಮೆಮೊ ಬರ್ಸ್ಕೊಂಡ್ ಬನ್ನಿ, ಷಣ್ಮುಖಪ್ಪ ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಹಾಕ್ಸಿ. ಯಾವಾಗ ಹಾಕಿದ್ದೀರಿ? ವಕಾಲತ್ತಲ್ಲಿ ನಿಮ್ ಸಿಗ್ನೇಚರ್ ಇದ್ರಲ್ಲಿ ಕಾಣ್ತಿಲ್ವೇ? ತೋರ್ಸಿದ್ ನೋಡಿ. ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೇನೆ, ಮೆಮೊ ತಗೊಂಬಂದು ಇಲ್ಲಿ ಕೊಡಿ. ನಾ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೇನೆ. ಇದಿಷ್ಟು ರೆಕಾರ್ಡ್ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೇನೆ, ರಿಸ್ಟೋರ್ ಆಗಲ್ಲ. ಹುಷಾರಿಲ್ಲ ಅಂದ್ರೆ ಮನೆಗೆ ಕಳಿಸಿ, ಯಾರನ್ನಾದ್ರೂ ಕ್ಲರ್ಕ್ನ ಸೈನ್ ಮಾಡಿಸ್ಕೊಂಡು ಬರ್ಲಿ. ದೊಡ್ಡ ಆಫೀಸ್ಗಳವ್ರು ಇನ್ನೊಬ್ಬರಿಗೆ ಮಾಡೆಲ್ ಆಗ್ಬೇಕ್ರಿ. ದೊಡ್ಡ ಆಫೀಸ್ ಅಂತ ಹೇಳಿ ನಾವು ಹೇಳಿದಾಗ ಕೋರ್ಟ್ ನಡೀಲಿ ಅನ್ನೋಂತ ಬಯಸ್ಬಾರ್ದು. ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ನನ್ನ ಕೊಡ್ತೀನಿ. The Learned Counsel for the petitioner, Sri Nataraj Babaki, Learned Counsel Sri Nataraj Babaki, claiming himself to be the Learned Counsel for the petitioner, has filed a memo for withdrawal of the writ petition. And a perusal of the record, it shows that the said Learned Counsel doesn't hold wakalat for the petitioner in this matter. As such, the matter stands passed over to enable the Learned Counsel to file another memo bearing the signature of the Learned Counsel who has filed wakalat in the matter. It is made clear that since his request for adjournment has already been rejected, the court would proceed to pass appropriate order when the matter is taken up in the second round, provided the memo of withdrawal which he intends to file is not filed. Yes.
Number 25, Bhaskar Hegde.
None appear. Pass over.
Number 26, Ramesh Hechi.
Police concern are taken. We do not needful to the needful to days. Vice concern Marathar. Fill an application.
Pass over ಮಾಡಿರ್ತೇನೆ ಮಾಡಿ. At the request of the Learned Counsel for the petitioner, matter stands passed over to enable him to do needful in the matter.
File. This is died. Don't know the date.
ಬೇರೆದೆಲ್ಲದು ಇದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ನಾನೇ ಫೈನಲ್ ಅಂತ ಕೊಟ್ಟಿದ್ದೇನೆ. ಎಲ್ಲಿ ನಾನು ಕಠಿಣವಾಗಿರ್ತೇನೆ ಅದನ್ನ ಹಿಂದ್ಗಡೆ ಎಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ನಾನು ನೋಡಿರ್ತೇನೆ, ಅದು ತಮಗೂ ಗೊತ್ತಿರುತ್ತೆ.
Number 27, Venkata Krishna.
None of your pass over.
Number 28, Sharan BT.
None of your pass over.
Number 29, Rajan Nasi.
ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೇನೆ, ಪ್ರೋಸೆಸ್ ಕಟ್ಟಿ ಬನ್ನಿ. ನೀವು ಪ್ರೋಸೆಸ್ ಕಟ್ಟೋದಾದ್ರೆ ನಿಮ್ಗೊಂದು 50 ರೂಪಾಯಿ 75 ರೂಪಾಯಿ ಒಳಗೆ ಖರ್ಚಾಗ್ತದೆ. ನಾನು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಟ್ಟು 1000 ರೂಪಾಯಿ ಫೈನ್ ಹಾಕಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ನಿಮಗದು ಬಹಳ ವಜೆ ಆಗುತ್ತೆ. ದುರಂತ ನೋಡಿ, ನಮ್ಮಲ್ಲಿ ವಕಾಲತ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಳ್ತಾರೆ. ವಕಾಲತ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡು ವಕೀಲರು ಇರಲ್ಲ, ಊರಲ್ಲಿ ಇರಲ್ಲ, ಬೇರೆದಕ್ಕೆ ಹೋಗ್ತಾರೆ, ಇನ್ನೊಂದ್ ಕಡೆ ಹೋಗ್ತಾರೆ. ಕಕ್ಷಿದಾರಗಳು ಹಣೆ ಬರ ನೋಡಿ. 25 ರೂಪಾಯಿ ಕಟ್ಟೋದನ್ನು ಕೂಡ ಕಟ್ಟಲ್ಲ. ದಮ್ಮಯ್ಯ ದಕ್ಕಯ್ಯ ದಮ್ಮಯ್ಯ ದಕ್ಕಯ್ಯ ಅಂತ ಹೇಳಿ ಕಟ್ಟಿಸ್ಕೊಳ್ಬೇಕು. ಅವ್ರು ಹೋಗ್ಲಿ ಊರಿಗೆ, ಒಂದು ಪ್ರೋಸೆಸ್ ಇದೆಯಪ್ಪ, ಪ್ರೋಸೆಸ್ ಕಟ್ರಿ ಅಂತ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಲಿಕ್ಕೆ ಆಗಲ್ವೇ? ಅದೂ ಇಲ್ಲ. 25 ರೂಪಾಯಿ ಕಟ್ಟೋ ಒಂದು ಮ್ಯಾಟರ್ನಲ್ಲಿ 2 ಗಂಟೆ ಬೇಕಾದ್ರೆ ಕಾದಿದ್ದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳ್ತೀರಿ ಹೊರತು ಆ 2 ಗಂಟೆ ಟೈಮಿನ ಪ್ರಿಷಿಯಸ್ ಟೈಮಿನ ಬೆಲೆ ಏನು ಒಬ್ರು ಅಡ್ವೊಕೇಟ್ಗೆ? ₹25 ಕಟ್ಟಲು 4 ಅಡ್ಜರ್ಮೆಂಟ್ ಬಂದು ಹೋಗಿ ಅಡ್ಜರ್ಮೆಂಟ್ ಕೇಳಿ. How much of manpower, time, dignity, labor is wasted? Noble profession in ಹಣೆ ಬರ. ಪಾಸ್ ಅವ್ರು ಮಾಡಿರ್ತೇನೆ, ಕಟ್ಟಿ ಇಲ್ದವರು ಪಾಸ್ ಫರ್ದರ್ ಆದ. The learned counsel learned counsel for the petitioner initially prayed for an adjournment. After perusing the previous day's order sheets, this court asked the learned counsel that the matter would be passed over so that he can suggested to the learned counsel that the matter would be passed over so that he can pay the process in the registry and report of doing needful in the matter to ensure the service of notice upon the respondent. In spite of court repeatedly, for which also the learned counsel for the petitioner shown his non-inclination to do needful. The court took further labor of bringing to his notice that just to pay a process of 25 rupees, the matter is being adjourned from time to time, and the precious time of the learned advocate as well as the court would be wasted in the said process. Further, if any cost is imposed by granting time to him, the quantum of the cost would be much more higher than the process fee he is required to pay. As such, he was again suggested to pay the process. For that repetitive suggestion also, the learned counsel shown his non-inclination to pay process and insists for time. Under the above circumstance and considering the nature of the petition and the fact that more than 9 months have already been lapsed after filing of this petition, I am not inclined to grant any further time. Accordingly, the petition stands dismissed for not taking steps. Yes.
Bill number 30, Ravi Kumar MC.
For the respondent.
Received copy.
Copies.
You have an objection to be filed?
Yes, sir.
Learned counsel from both sides present. Learned counsel for the K beta acknowledging the receipt of the copy of memorandum of rate petition along with annexes, prays for a short accommodation to file his objection. 10 days time as paid is granted.
Hearing on. Utility application number 31, Amaresh Angadi. Yes, Sanmati for respondent 1.
Respondent number.
What the petition is about? You have no objection to condone delay?
No objection.
As well to allow LR application?
Petitioner is dead. They are challenging the order passed in the execution petition, Lord. I being an insurance company filed execution petition to recover the amount. There has been, their contention is that I have filed this execution petition beyond the 12 years, therefore it is not maintainable. My contention is that when I received the award amount, our decree, when it was signed and received it within time limit of 12 years, I have filed it within time. Whether it is within time limit or not, that has to be decided. Award sign ಮಾಡಿದ್ದೀನಿ ಅನ್ನೋದು award
Further submission in the learned counsel from both side on pending IAS. The learned counsel for respondent submits no objection to allow IA 1213 of 2023. There was IA 1/23 filed under section 5 limitation act so and so. IA allowed a delay of 2 days condoned. Two and three abatement LR application. We have to format actually. Allow petitioner to carry out the necessary amendment in the spirit petition within a week from today and to file the amended memorandum of petition within 2 weeks from today in the registry, however duly serving copies thereof to the respondent. List the matter on a 92. Yes.
Till number 32, Kirti Prasad.
Your Lordship, for the petitioner, in the prior column of the petition, the IA number 1 is shown instead of IA number 4, Your Lordship. For that, I have sought for amendment. It's by oversight.
Further submission of learned counsel for the petitioner on IA 1 of 24 filed under so and so. Considering the reason showing the affidavit accompanying the application as well the submission. The IA number 1/24 stands allowed. The petitioner is permitted to carry out the amendment as sought for in IA 1/24. The petitioner to carry out the amendment within a week from today. Yes.
Preliminary matters, still number 33, Supreet S.
At what stage of the suit the application was filed?
The pleading applications were pending. It was at that stage, the amendment of.
Whether the trial has begun,
It was posted for hearing on IS.
the trial has not yet been commenced.
Trial had not commenced. Now, even now, the trial has not yet commenced for the reason there is one more pleading application that is filed and summons has been not. Properties that is sought to be included are the properties that was acquired by my client subsequent to the filing of the suit.
Further submission of land counsel for the petitioner who is physically present in the matter. There is the memorandum of petition and the impugned order. Issue emergent notice to the respondents. In the meantime, there shall be an interim stay of the interim stay as prayed for a period of 3 weeks from today. The petitioner to pay the necessary process and furnish copies in the registry within a day from today. Failing which the interim order passed today would not renew to the benefit of the petition. List the matter on 22.
Bill number 35, Varadarajan MS.
The notice has not been ordered. Let emergent notice book. Heard the submission of land counsel for the petitioner. Produce the memorandum of petition with its annexures. Issue emergent notice to the respondent.
Because the second suit filed against me by the plaintiff, same property. The first suit is still pending. It's also for partition. In that suit, an ex parte order of injunction had been granted in his favor.
What was the order of the trial court?
The order of the trial court is.
Did it grant injunction?
Granting injunction restraining me from selling this property.
Yes.
That was the prayer made in the earlier suit also by the plaintiff. Earlier suit is also for partition. An ex parte order granted in that suit was vacated at my instance. Thereafter, the present suit is filed only with respect to this property. The earlier suit comprises of 5 properties, including this property. Page 122 is the order passed in the earlier suit. Their injunction is vacated at my instance. Again, he files the second suit for partition only with respect to this property and then obtains an injunction order against me.
You preferred an MA.
I preferred an MA. MA is also dismissed. But both the courts say, notwithstanding the fact that the injunction order was vacated in the earlier suit, still interest of justice requires that the property should be preserved in its present status. That is the only reason given by both the courts to continue the injunction. All that was considered in the earlier suit and then injunction is vacated. That has attained finally.
Let emergent notice book. Petitioner to pay the necessary process and furnish copies in the registry within a day from today. List the matter on 14.
Cell number 36, and Kumar Jain.
Respondent, my lord. My lord. Yes. Statement objection is ready,
File it in the registry.
please.
Learned counsel from the both side present. Learned counsel for caveat or submits that he has filed statement of objection to the writ petition. List the matter on 1, 2.
Cell number 37, Halli Santappa Basappa.
The dependent petition matter.
Do you have any objection for his request for time? Learned counsel for the petitioner and caveat are present. The repeated request of the learned counsel for the caveat for some more time to file his objection to the petition is not opposed to the petition. On the contrary, he submits no objection to grant a reasonable time. Hence, 10 days time as spread is granted.
Please, my lord.
Cell number 39, Arvind Reddy.
Right, so for a direction to the causing that. About rupees 17 lakh 61,335. Containing that the land was subjected to acquisition by the National Highway Authority, Department of 4, and the compensation amount has been paid to the second individual. But connection with that should not moment that the written statement filed by the acquisition authority.
1 minute.
Please.
deposit 50% of the amount.
I think before that, my lord, kindly see the written statement filed by the acquisition authority.
Then we will order for emergent notice. Further submission of learned counsel for the petition. After hearing his submission, though the court shown its inclination of granting a conditional interim order, subject to the condition of the petitioner depositing 50% of the amount shown in the impugned order in this court. The learned counsel for the petitioner is not inclined in that direction. Hence, as prayed for, issue emergent notice to the respondent, returnable by 22/2/2024. The petitioner to pay the necessary process and furnish copies in the registry, if not already done, within a day from today. Yes.
Great.
Till number 41, P. Chinnappa.
This is an order of the commercial court, where an application for deletion from the area of parties is being not dispensed. The short point here is that the plaintiff constitutes a suit, primarily on the premise that if you also the kind of take the plaint, or not the plaint would be at page 100, annexure C.
1 minute.
I'm sorry,
Please. 1 minute.
please.
Where is the plaint at page?
Page 100, Lordship will kind of take page 100. But in the, I am Lord D2 in the suit. D1 and D3 came to be amalgamated, therefore Lord D1 is struck off from the area of parties. The only allegation against me is paragraph 26. And that is also factually not correct. That is at page Lord 112. Last 7-8 lines of paragraph 26. The only allegation made is that particular invoice was paid by defendant number 2 through defendant number 3. I did not pay it. The record shows that D3 paid it, not me. But the prayer is sought against me also. Absolutely not any other allegation brought against me. Ultimately, the contract is only between what was D1, now D3, and the plaintiff.
You are defendant number 1.
No, my lord, I am defendant. I'm different number. The suit, I'm different.
No. Look at in the writ petition,
Please.
description of the party, cost title.
Alright, there is an error. There is an error.
Correct,
There is
rectify.
an error. There is an error. It should be rectified.
Land counsel for the petitioner, who is physically present,
This is an error.
submits that the writ petitioner is defendant number 2
Please.
in the trial court. Admittedly, his description in the cost title of the writ petition is shown that he was defendant number 1 in the trial court.
ಅದು respondent to good even ಅಂತ ತೋರಿಸಿದ್ದಾರೆ petitioner good even. Please correct it.
The petitioner is directed to do needful, like the petitioner to do needful in this matter to show his correct description in the cost title. List the matter on 2-2.
So,
Serial number 42, Vinayaka VS, for respondent number 4.
Respondent number 1, David. Yes, other matter is pending, my lord, filed by the second respondent hearing, my lord.
Counsel for the petitioner, neither present physically nor through video conference, counsel for
Respondent number 1,
respondent number
1 David.
1, K. Waiter alone is present, hence the matter could not be.
21-030, my lord. It is maybe connected, my lord.
Now, how that is connected?
The second respondent herein filed the another writ petition, my lord.
No, is it with respect to the very same impugned order?
Very same order.
The counsel for the K. Waiter submits that against the very same impugned order. One more writ petition, W number so and so is also pending before this court, and please list both the matters together, register it, verify, and
In the post.
if both the writ petitions are challenging the very same order, list them together.
Next week, my lord, anything.
Together, list the matter on 6-2.
Please, my lord.
Preliminary B group matter, serial number 48, SV Prakash, VN Shetty for respondent.
They have not completed the interim order granted by this court.
The counsel for the petitioner neither present physically nor through video conference. The counsel for the respondent alone is physically present. And submits that the petitioner have neither complied the terms of interim order nor is appearing and proceeding further in the writ petition as such, intentionally causing delay in disposal of this writ petition. Next, the perusal of the order sheet will go to show that this writ petition is of the year 2018. As such, one of the old writ petition of this nature pending before court. On the previous date of hearing, that is on 7/7/2023, the matter stood adjourned at the request of the learned counsel for the petition. Once again, when the matter was listed on 21/7/2023, the matter was adjourned again at the request of the petition. In spite of granting sufficient time, petitioner. Thereafter, when the matter was called on 3/11/2023, the learned counsel for the petitioner was neither present physically nor through video conference. It was only the learned counsel for the respondent alone who was present. Thus, it shows that the petitioner is not inclined to prosecute the matter. As such, the petition stands dismissed for non-prosecution.
Serial number 52, Guraj Kulkarni.
The counsel for the petitioner not present, let counsel for the respondent alone present. On 3/1/2024 also, the learned counsel for the petitioner had remained absent. Hence making it clear that in case if the petitioner fails to appear on the next date of hearing, the court may proceed to pass appropriate order, including dismissal of the petition for non-prosecution as a final opportunity. A week's time is granted. List the matter on 5/2.
Serial number 53, Pradeep HS, Warrant P.
Yes, for adjournment.
Last time also you had taken time.
Your father admitted in hospital last patient.
ಕಾರಣಗಳು ಪ್ರತಿ ಸಿಗ್ತದ್ರಿ, ಪ್ರತಿ ಸರ್ತಿ ಕಾರಣಗಳು ಕೊರತೆ ಅದು ವಕೀಲರುಗಳಿಗೆ. ಚಿತ್ರಗುಪ್ತರು ಯಮಧರ್ಮನಿಗೂ ಕಾರಣ ಸಿಕ್ಕದೇ ಇರಬಹುದು, ಅಡ್ಜರ್ಮೆಂಟ್ ವಕೀಲರುಗಳಿಗೆ ಸಿಗ್ತದೆ. The learned junior counsel for the petition. ಈ ಸರ್ತಿ ಏನ್ ಕಾರಣ ಅಡ್ಜರ್ಮೆಂಟ್ಗೆ? ಇನ್ಕನ್ವೀನಿಯನ್ಸ್, ಪರ್ಸನಲ್ ರೀಸನ್, ಹೆಲ್ಡ್ ಅಪ್, ನಾಟ್ ಫೀಲಿಂಗ್ ವೆಲ್ಲು, ಅಡ್ಜರ್ಮೆಂಟ್ ಕಾರಣಗಳೇ ಅಲ್ಲ ಅವು, ಕಾರಣಗಳೇ ಅಲ್ಲ. ನೀವು ಅದನ್ನ ಹೇಳ್ತೀರಿ, ನಾವು ಹೂ ಅಂತೀವಿ, ನೀವು ಅದನ್ನೇ ಕಲಿತೀರಿ. ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಹೀಗಿರ್ಲಿಲ್ರಿ, ನಿಜವಾಗಿಯೂ ಬಾರ್ ಹೀಗಿರ್ಲಿಲ್ಲ. ನಾನ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾ ಹಳಬರು ಕೂತಿದಾರ ಹಿಂದೆ, ಕೇಳಿ ನೋಡಿ ಹೇಗಿತ್ತು ಅಂತ. ತಪ್ಪು ಹಳಬರದ್ದು, ಕೂತಿದ್ದಾರೆ, ಅವ್ರಿಗೂ ಬೈತಿದ್ದೇನೆ ನಾನು. ಹಳಬರದ್ದು ಅವರು ಯಂಗ್ಸ್ಟರ್ಸ್ ಜೂನಿಯರ್ಸ್ಗಳು ಏನೋ ಕಾರಣ ಕೊಡ್ತಾ ಅವ್ರಿಗೆ ಅಯ್ಯ ಕುತ್ಕೋ, ಹಿಂಗೆಲ್ಲ ಹೇಳಬಾರ್ದು, ಇದು ಹೈಕೋರ್ಟು, ಹಿಂಗೆಲ್ಲ ಕಾರಣಗಳನ್ನು ಕೊಡೋದಲ್ಲ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ರೆ ಸರಿ ಬರ್ತಿತ್ತು. ನಮಗೆ ಯಾಕೆ ಅಂತ ಅವ್ರು ಸುಮ್ಮನಿರ್ತಾರೆ. ನೀವು ಜೂನಿಯರ್ಸ್ಗಳು ಅದನ್ನೇ ಬೆಳೆಸ್ಕೊಂಡು ಹೋಗ್ತೀರಿ, ಅದೇ ಕರೆಕ್ಟ್ ಏನೋ, ಅದೇ ಕರೆಕ್ಟ್ ಸಿಸ್ಟಮ್ ಏನು ಅಂತ.
Junior counsel for the petitioner.
Okay.
Learned junior counsel for the petitioner.
Once again press for a short accommodation, however this time by stating that his senior has got some personal inconvenience. Next, on 25/10/2023 also he had taken time citing the alleged not keeping well of his senior.
Senior's father.
In the light of the above, making it clear that no further adjournment will be granted in this matter of the year 2019 as a final opportunity. A week's time as prayed is granted.
Serial number 55, Shamegowda HB, Ramkrishnaya MG, correspondence.
what were the instructions, memo of instruction you intended to give to the commissioner?
Determine whether the.
Where is that memo of instruction?
The sport commission was not appointed.
No.
The affidavit I mentioned was the reason my.
It is not necessary that only after appointing the court commissioner you should give the memo of instruction. Your application, you should make it very clear for what purpose you intend to appoint a court commissioner.
Application. Affidavit was in page number 39 mechanics. In 9 blocks, in the middle portion.
1 second.
Please.
Okay, 9.
39 blocks. In
Yes.
the middle portion, there are some paragraphs which is just necessary. It's in the middle. Exhibits P7 to P19, 19 to P23 clearly shows the encroachment of my property under these circumstances. It is just necessary to appoint the road commissioner to conduct local inspection in order to investigate and find out whether the defendants have extended the subject from the first floor level onwards in property number 11 and the said extension of subject have encroached my property number 14. Whether the defendants have left setback area towards drainage side eastern side of property number 11. Point 3 was whether the defendants have caused any damage to the sheets on the roof of my house. The appointment of court commissioner is very much necessary. About this for determining.
Don't you have any alternate to prove your allegation of the alleged encroachment?
The peculiar facts and circumstances of this case are such that, without the aid of, apart from photographs and my oral evidence, there is nothing else, that I can produce to establish my contention through the encroachment. And also, moreover, this court, the coordinate bench of this court has also held that through encroachment, this court commissioners are just a necessary. Assistance of court commissioner is very much necessary. Is what was the recent judgment. This coordinate bench.
My respect is the defendants are neighboring owner to this proceeding. Schedule A, Lordship kindly take it. Schedule A, in the Schedule B, nowhere the property of the defendant is situated. In the evidence also admitted. The PW1.
Appreciation of evidence is at the later stage. Cross-examination of PW1, you cannot draw our attention at this stage and say. The fact remains that
But my
they are the plaintiff. They contended they are your neighbors.
in the cross-examination, the evidence also, my right, they have admitted they are not, we are not encroached any property of the plaintiff's property. I have constructed in my property. See, due to enmity, this suit was filed. But in the evidence, ಪ್ರತಿವಾದಿನ ಸಂಖ್ಯೆ ಗೊತ್ತಿಲ್ಲ. ಪ್ರತಿವಾದಿಯರ ಸತ್ತು ದಾವಾ ಸತ್ತಿನ ಪಕ್ಕದಲ್ಲಿ ಬರುವುದಿಲ್ಲ. Evidence of PW1. Evidence of PW1. It is in the evidence. They are not producing the evidence. But ಪ್ರತಿವಾದಿ ಸತ್ತಿನ ಸಂಖ್ಯೆ ಗೊತ್ತಿಲ್ಲ. ಪ್ರತಿವಾದಿಯರ ಸತ್ತು ದಾವಾ ಸತ್ತಿನ ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಬರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಪ್ರತಿವಾದಿಯರ ಸತ್ತು
ಬರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ.
ಮುಂದೆ ಸ್ವಾಮಿ, ಪ್ರತಿವಾದಿಯರ ಸತ್ತು ಯಾವ ದಿಕ್ಕಿಗೆ ಬರುತ್ತದೆ ಎಂದು ಹೇಳಲಾಗುವುದಿಲ್ಲ. ಒಂದನೇ ಪ್ರತಿವಾದಿಯರ ಸತ್ತು ನೀತಿಯೊಂದರ ಕರೆಯ ಪತ್ರದಲ್ಲಿ ಯಾವ ದಿಕ್ಕಿಗೆ ಬರುತ್ತದೆ ಎಂದು ಹೇಳಲಾಗುವುದಿಲ್ಲ. ದಾವಾ ಸತ್ತಿನ ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಪ್ರತಿವಾದಿಯ ಸತ್ತು ಬರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. The evidence of PW1, evidence of PW2 or wife, husband. ನಾನು ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಬರೆಸಿದ ವಿಳಾಸದಲ್ಲಿ ಹುಟ್ಟಿದಾಗಲಿಂದಲೂ ವಾಸವಿರುತ್ತೇನೆ. ಆದರೆ ಯಾವ ಬಗ್ಗೆ ದಾಖಲೆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ವಾದಿಯವರು ಈ ದಾವೆಯನ್ನು ಯಾವ ಪರಿಹಾರ ಕೋರಿಸಿದ್ದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ವಾದಿಯವರ ಮನೆ ನಂಬರ್ ಇರ್ತದೆ. ಸ್ವಾಮಿ, ಎವಿಡೆನ್ಸ್ ಆಫ್ PW2. ಹಸ್ಬೆಂಡ್ ಸ್ವಾಮಿ, ವಾದಿ ಸತ್ತನು ಆಗಸ್ಟ್ 25ರಂದು ಕ್ರಯಕ್ಕೆ ತೆಗೆದುಕೊಂಡಿದ್ದಾನೆ.
ವಾದಿ ದಾವಾ ಸತ್ತಿನ ಕರ್ನಾಟಕ ಕೊಳಗೇರಿ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿಯಿಂದ ಕ್ರಯಕ್ಕೆ ತೆಗೆದುಕೊಂಡಿರುವುದು ನಿಜ. ದಾವಾ ಸತ್ತಿನ ಪೂರ್ವಕ್ಕೆ ನಮ್ಮ ಮನೆ ನಂಬರ್ 14 ಬರುತ್ತದೆ ಸತ್ತು. ಪಶ್ಚಿಮಕ್ಕೆ ಚರಂಡಿ, ಉತ್ತರಕ್ಕೆ 14ನೇ ನಂಬರ್ ಮನೆ, ದಕ್ಷಿಣಕ್ಕೆ ರಸ್ತೆ ಇರುತ್ತದೆ. ನಾವು ಕೊಳಗೇರಿ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿ ಸತ್ತನ್ನು ಕ್ರಯಕ್ಕೆ ಪಡೆದಿರುವ ರೀತಿಯೇ ಪ್ರತಿವಾದಿ ಕೊಳಗೇರಿ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿಯಿಂದ ಕ್ರಯಕ್ಕೆ ಪಡೆಯುತ್ತಾರೆ ಎಂಬುದು ನಿಜ. ನಮ್ಮ ದಾವಾ ಸತ್ತಿನ ಸಂಖ್ಯೆ 14 ಇರುತ್ತದೆ. ಒಂದೇ ಪ್ರತಿವಾದಿ ಸಂಖ್ಯೆ 11 ಇರುತ್ತದೆ. In the plaint, my lord. In the plaint.
Plaint is at page?
Once plaint is at page number 14 to 21.
In page 19, my lord. In page 19. A schedule property. Nowhere the property.
A schedule, whose property is A schedule property, whose property is B schedule property?
Well, A schedule is mine.
A schedule property is your property.
And the boundaries, my nowhere is our property number 11, my lord.
1 minute, 1 minute, 1 minute. According to you, the defendant's property is adjacent to your property, right?
No, nowhere.
1 minute.
My lord, in the
1
plaint-
minute, please.
In between both are, because there exists a drainage, it's also there. They have put a pillar on the drainage. And
Yeah.
because they have extended the roof, every floor below they extended by 1 feet.
No,
My lord.
where do I find that between both of your property, there exists a drainage?
West by drainage suddenly, my property, Asian property. Asian property.
Sir, looking at the schedule, we cannot say whether the drainage has been enclosed by him and whether that drainage exists as a common drainage portion between both of your property. There must be some recital in the plaint to that effect, stating that between my house and the house of the defendant, there exists a drainage.
Plus, I have said in para number 4 regarding drainage. My last kindly see
My lord.
page number 16.
My lord, in the order, on submission.
ಒಂದು ನಿಮಿಷ ಅವ್ರಿಗೆ ಅವ್ರನ್ನ ಕೇಳ್ತಿದ್ದೇನೆ.
Sorry,
ಆ ಮಧ್ಯ
sorry.
ಧಾವಂತ ಯಾಕೆ ಅವ್ರದಾದ್ಮೇಲೆ ನಿಮ್ಮನ್ನು ಕೇಳ್ತೇನೆ.
Sorry.
ಇರಿ ಒಂದ್ ನಿಮಿಷ.
Page number 16 also.
Yes,
Para 4,
yes,
7th line.
yes.
The difference without.
1 minute. In page 16, para 4, 7th line. ಓದಿ.
6th line. The
Ah.
difference without obtaining license to operate authority without following the bylaws procedure by encroaching the drainage space and also encroaching the plaintiff's property.
ಪೂರ್ತಿ ಸರಿ ಓದ್ಕೊಂಡು ಬರ್ಬೇಕ್ರಿ. ಅದೇ ಪ್ಯಾರಾದಲ್ಲಿ ಥರ್ಡ್ ಲೈನ್ ಓದಿ ಮೇಲ್ಗಡೆಯಿಂದ.
In between.
ಹಾ.
Property of the plaintiffs, but there is a drainage.
ಓದಿ ಅದನ್ನ.
In between the property of the plaintiff and defendant, there is 3.5 feet width drainage.
ಮತ್ತೆ ಹೇಳಿದ್ದೀರಿ ಅಲ್ವೇ? ಅದನ್ನ ಕೇಳಿದ್ರೆ ಅದನ್ನ ಬಿಟ್ಟು ಬೇರೆದನ್ನ ಏನೋ ಓದ್ತೀರಿ. ನಿಮ್ ಕೇಸ್ ನೀವೇ ಓದ್ಕೊಂಡು ಬರಲ್ಲ. Yes, please.
In the plaintiff, A scheduled property. Nowhere the property of the plaintiff is described.
Nowhere.
Dependent's property. West by Gully.
Defendant's property in the schedule.
In the
B schedule.
Nowhere mentioned. Nowhere mentioned in the schedule A property.
Oh.
Whether east by Gully. West by drainage. Currently. North by house number 13. South by road. Nowhere our property is number 11.
That is true. His case is not that say your property is abutting his property. It is not. If it is abutting, then the question of you, what you said, that would arise. It is not abutting property.
My lord, nowhere in the plaint or in the evidence. On the other hand, evidence of PW2. ನಮ್ಮ ಸತ್ತಿನ ಯಾವ ಭಾಗದಲ್ಲಿ ಒಂದನೇ ಪ್ರತಿವಾದಿಗೆ ಸಂಬಂಧಿಸಿದ ಸತ್ತು ಬರುವುದಿಲ್ಲ ಎಂಬುದು ನಿಜ. Evidence of PW1 and PW2 clearly admitted that nowhere the properties, defendant property situated of their property.
ಆಯ್ತು, ಹಾಗಾದ್ರೆ if that were to be the case, even if the commissioner comes there, you can be pretty well happy and sure.
I agree, but the defendant's property is not adjacent to the plaintiff's property nowhere. Their evidence clearly established that. That is what of the trial court has clearly that in page 53, my lord. Para 9, my lord. Para 9, my lord.
Yes.
For contra, the defendants have contended the application is not maintainable. The allegation made in the application are all concocted. The said application is filed with ulterior modified to harass the defendant. In the cross-examination of PW1, she herself has stated the defendant's property is not situated nearby the suit scheduled property. The plaintiff cannot say on which side the defendant's property is situated. The witness examined on behalf of the plaintiff also stated that they do not on which side the defendant's property is situated. Thus, based on the evidence on record, the application is misconceived in the plaintiff. The plaintiff has mentioned the alleged A scheduled property and B scheduled property has given the particulars. Further, she has mentioned the alleged measurement of A scheduled property and its boundaries. Now, the plaintiff has come with application to appoint a court commissioner to conduct the spot inspection of alleged A and B scheduled properties and submit report. Court commissioner cannot be appointed to collect the evidence. Plaintiff has established her case by adducing oral and documentary evidence. Then the case is posted for arguments at the back end of the plaintiff. The plaintiff has come up with this application only to drag on the proceedings. Thus, the application is misconceived. The suit itself is not maintainable in law. There is no merit in the application. The balance of conditions is also in favor of the defendants.
Yes.
My lord, on the other hand, my lord, the evidence of PW1 and PW2 is clearly stated on which side the defendant's property, our property is number 11. My lord, kindly take it to the plane. Nowhere. In the plaint, schedule A. Schedule A. Nowhere on the boundaries west, north, south. The property of the defendant is not mentioned on any side of the property. But drainage, surrounding. Nowhere, at least they have to be mentioned the dependent's property. They are not mentioned. Moreover, my lord,
Yes.
the evidence of PW1 and PW2.
Yes.
ಪ್ರತಿವಾದಿಯ ಸತ್ತು ಯಾವ ದಿಕ್ಕಿಗೆ ಬರುತ್ತದೆ ಎಂದು ಹೇಳಲಾಗುವುದಿಲ್ಲ. ಒಂದೇ ಪ್ರತಿವಾದಿಯ ಸತ್ತು ನೀತಿ 1ರ ಕ್ರಯಪತ್ರದಲ್ಲಿ ಯಾವ ದಿಕ್ಕಿಗೆ ಬರುತ್ತದೆ ಎಂದು ಹೇಳಲಾಗುವುದಿಲ್ಲ. ಎವಿಡೆನ್ಸ್ ಆಫ್ PW1 plaintiff. ದಾವಾ ಸತ್ತಿನ ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಪ್ರತಿವಾದಿಯರ ಸತ್ತು ಬರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. Can I pass this?
Yes. Mark this portion and it.
ಮಾಡಿದ್ದೀನಿ.
Yes. That is all from both.
PW2 evidence.
Yes.
PW2 evidence also, my lord.
Yes.
ವಾದಿಯವರ ಎವಿಡೆನ್ಸ್ ಆಫ್ PW2.
Yes.
ಪ್ರತಿವಾದಿಯವರ ಸತ್ತು ಯಾವ ಪಕ್ಕದಲ್ಲೂ ಬರುವುದಿಲ್ಲ. ಎವಿಡೆನ್ಸ್ ಆಫ್ PW2 ಅವರ ಹಸ್ಬೆಂಡ್.
PW1, PW2 ಇಬ್ಬರದು ಹೇಳ್ತಾರೆ. PW2 English version. No, what you passed over it is PW2 where he has stated. Mark ಮಾಡಿ.
Sorry. My lord, the PW2 is the husband of plaintiff. My lord, so in the Schedule B property, my lord, in the Schedule A property or in the Schedule B property is our, they have stated with my property. At least they have mentioned their property, on which side they have not mentioned. Or nowhere stated.
11 ಸರ್ತಿ ಹೇಳಿದ್ರಿ ಅದನ್ನೇ ನೀವು,
ಸ್ವಾಮಿ.
ಈಗ 12ನೇ ಸರ್ತಿ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀರಿ.
ನಾನು ಹೇಳಿದ್ದು Schedule A ಬಗ್ಗೆ, Schedule B ಬಗ್ಗೆ ಹೇಳ್ತೇನೆ.
ಎರಡನ್ನೂ ಹೇಳಿದ್ದೀರಿ
Does not tally.
ಅಲ್ವೇ? ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಪಕ್ಕದಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಆದ್ರೆ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಪಕ್ಕದಲ್ಲಿ ಇಲ್ಲ ಅಂತಲೇ ಅರ್ಥ. ಎರಡರಲ್ಲಿ ಒಂದ್ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ಅದು ಬರಲೇಬೇಕು. ಅವ್ರ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ಬಲಕ್ಕೆ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಅಂದ್ರೆ ನಿಮ್ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ಎಡಕ್ಕೆ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಅಂತ ತೋರಿಸ್ಬೇಕು. ಅದು ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟಿನ ಸಾರಾಂಶ.
ಸ್ವಾಮಿ, ನಮ್ಮ ಶೆಡ್ಯೂಲ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ತೋರಿಸಿದ್ವಿ ಸ್ವಾಮಿ. ಇನ್ ದಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮೇಲೆ, ಇನ್ ದ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
Have you disputed that B schedule property is not your property?
Nowhere our property is situated. Or in the.
You are not answering my question specifically. Have you anywhere in your written statement stated that B schedule property is not your property?
But
answer my question first.
My lord, I agree, but I have not encroached any property. I am not encroached.
That is different, sir.
My lord,
that is different.
My lord, in page 28, you last speak it. In page 28, written statement schedule property. My lord, I have clearly stated, my lord. I have clearly stated, my lord. I have not encroached. My lord, I have clearly stated, my lord. I have not encroached any property of the plaintiff in the written statement. My property is described as a written statement schedule property. In page 28, my lord.
Yes.
My lord, further, in page 24, para 7 of written mistake. In
Yes.
page 24,
Yes.
para 7.
Yes.
I have clearly, the dependent one submit that alleged plaintiff's property is not all adjacent to the dependent's one property in any one of the boundaries of the written statement schedule property.
Yes.
Then the suit filed by the plaintiff is not maintainable either in the or on fact.
Yes.
My lord, it is my submission.
Yes.
Appointment of court commissioner is not abusing, not abused. My respective submission. When the property of the plaintiff is not any one of the boundaries, appointment of court commissioner does not arise. That is what observed by the trial court. My respective submission, please, Your Honor, appointing a court commissioner. Our property is not situated to the plaintiff's property. It is only abusing the due process of law.
Yes.
The alleged encroachment or it is a matter of trial.
Yes.
My respective submission, please, Your Honor, the appointment of court commissioner.
Yes.
When my dependent property is not set any of the boundaries of the plaintiff A schedule property or B schedule property. My lord, in the B schedule also, our property is not mentioned, or the plaintiff's property.
Have you produced your approved plan with a dimension?
My lord, they have not also produced any document in order to show that.
My question is, have you produced? ಅದಕ್ಕೆ ಉತ್ತರ ಕೊಡಿ.
One submission, my lord.
ಯಾಕಪ್ಪ ಅದನ್ನ ಮಾಡಿದೀನಿ ಅವ್ನು ಮಾಡ್ಲಿಲ್ಲ, ಅದು ಉತ್ತರ ಅಲ್ಲ.
ಸ್ಲಮ್ ಏರಿಯಾ ಇದು ಏನ್ ಗೊತ್ತಿದೆ, BBMP ವ್ಯಾಪ್ತಿ ಕೊಡಲ್ಲ.
ಸ್ಲಮ್ ಏರಿಯಾದಲ್ಲಿ
ಅಲ್ಲ ಸ್ವಾಮಿ.
ಯಾವ ಪ್ಲಾನ್ ಗೀನ್ ಅಪ್ರೂವಲ್ ಇಲ್ಲದೆ ನೀವು ಇಷ್ಟ ಬಂದಾಗ ಕಟ್ಕೊಳ್ಬಹುದಾ?
ಅಲ್ಲ ಹಂಗಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಗೌರ್ಮೆಂಟ್ ಪರ್ಮಿಷನ್ ತಗೊಂಡಿದ್ದೀವಿ ನಾವು ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀವಿ.
ಅಲ್ರಿ, ಕಟ್ಟಡದ ರಚನೆಗೆ ಯಾವುದೇ ನಕ್ಷೆ ಅನುಮೋದನೆ ಇಲ್ಲದೆ ನೀವು ಕಟ್ಟಡ ಕಟ್ಟಬಹುದಾ?
ಸ್ವಾಮಿ ಅದರಲ್ಲಿ ಸಮ್ ಕ್ಲಿಯರೆನ್ಸ್ ಬೋರ್ಡ್ ಇಂದ ಅನುಮತಿ ತಗೊಂಡು ಕಟ್ಟಿದ್ದೀವಿ. ಅದು ಪ್ರೊಡ್ಯೂಸ್
ನನ್ನ
ಮಾಡಿ.
ಪ್ರಶ್ನೆ, ನೀವು ಯಾಕೆ ನೀವು ಕೋರ್ಟಿನ ಪ್ರಶ್ನೆಗೆ ನೀವು ನೇರ ಉತ್ತರ ಕೊಡಲ್ಲ, ಸುತ್ತಿ ಬಳಸಿ ಬೇರೆದನ್ನೇ ಹೇಳ್ತೀರಿ? ಇದು 6ನೇ ಪ್ರಶ್ನೆ, ನೀವು ನೇರ ಉತ್ತರ ಕೊಡ್ತಾ ಇಲ್ಲ. ಪ್ರಶ್ನೆ ಕೇಳಿದಕ್ಕೆ ಬೇರೆದೇ ಉತ್ತರ ಕೊಡ್ತೀರಿ ನೀವು.
ಇದು 50 ವರ್ಷದಿಂದ ಇರ್ತೀವಿ ನಾವು ಸ್ಲಮ್ ಅಲ್ಲಿ ಅವಾಗ
ಅಲ್ರಿ, ಕಟ್ಟಡ ಈಗ ಕಟ್ತಾ ಇದ್ದೀರಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಸುಳ್ಳು. ನಾವು 50 ವರ್ಷದಿಂದ
ಅಂದ್ರೆ ಕಟ್ಟಡ ಕಟ್ತಾ ಇರೋದು 50 ವರ್ಷ ಹಳೇದು.
50 ವರ್ಷ ಬರ್ಲಿ ಸಮ್ ರಿನೋವೇಷನ್ ಅಷ್ಟೇ ಸರ್. 50 ವರ್ಷದಿಂದ
ವಕೀಲ್ರೆ, ನೀವು ಯಾಕೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಕೋರ್ಟ್ ಇನ್ನೂ ಪ್ರವೋಕ್ ಮಾಡ್ತಿದ್ದೀರಿ ಜಾಸ್ತಿ ಅಬ್ಸರ್ವ್ ಮಾಡ್ಲಿಕ್ಕೆ? ಅದನ್ನೆಲ್ಲ ನಾನು ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ ಬರ್ದೆ, ನನ್ನ ಅಬ್ಸರ್ವೇಷನ್ ಅಲ್ಲಿ ಬರ್ದೇನೆ ನೀವು ಸನದ್ ಕಳ್ಕೊಳ್ತೀರಿ.
ಸಾರಿ
ಸನದ್ ಕಳ್ಕೊಳ್ತೀರಿ.
ಸಾರಿ ಪ್ಲೀಸ್ ಸ್ವಾಮಿ. ಏನ್ ಗೊತ್ತಾ, ಅಲ್ಲಿ 50 ವರ್ಷದಿಂದ ಇದ್ದೀವಿ ನಾವು. ಅದು ಸಮ್ ಕ್ಲಿಯರೆನ್ಸ್ ಪರ್ಮಿಷನ್
50 ವರ್ಷದಿಂದಲೇ ಇರ್ರಿ, ನಾಲ್ವಡಿ ಕೃಷ್ಣರಾಜ ಒಡೆಯರ್ ಕಾಲದಲ್ಲೇ ಇರ್ರಿ. ಆದರೆ ಈಗ ಕಟ್ಟಡ ಕಟ್ತಾ ಇದ್ದೀರಿ ಅನ್ನುವ ಸಂದರ್ಭದಲ್ಲಿ ಆ ಕಾಲಕ್ಕೆ ನೀವು ಸಂಬಂಧಪಟ್ಟ ಪ್ರಾಧಿಕಾರದಿಂದ ಯಾವುದೇ ಅನುಮತಿ ಪಡೆಯುವ ಅವಶ್ಯಕತೆ ಇಲ್ಲವೇ?
ಸ್ವಾಮಿ ಅದು ಸಮ್ ಕ್ಲಿಯರೆನ್ಸ್ ಬೋರ್ಡ್ BBMC ವ್ಯಾಪ್ತಿಗೆ ಬರಲ್ಲ.
ನಾನು BBMP ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. ನೀವು ಯಾತಕ್ಕೆ ನಿಮಗೆ ಅನುಕೂಲವಾಗುವ ರೀತಿ ನೀವು ಪ್ರಶ್ನೆನ ಅರ್ಥ ಮಾಡ್ಕೊಂಡು ನೀವು ಅದಕ್ಕೆ ಉತ್ತರ ಕೊಡ್ಲಿಕ್ಕೆ ಹೋಗ್ತೀರಿ. ಪ್ರಶ್ನೆನ ನೇರ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ.
ಸ್ವಾಮಿ ನಾವು ಗೌರ್ಮೆಂಟ್ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಕಟ್ಟಿದ್ದೀವಿ.
ಕಟ್ಟಡ ಕಟ್ಟಲಿಕ್ಕೆ ನಕ್ಷೆ ಯಾರು ಅನುಮೋದನೆ ಮಾಡಿದ್ದಾರೆ?
ಅದು ಯಾರು ಅನುಮೋದನೆ ಮಾಡಿದ್ರೆ ಗೌರ್ಮೆಂಟ್ ನವರು ಅಪ್ರೂವ್ ಕೊಟ್ಟವ್ರೆ.
ತೋರಿಸಿ ಅದನ್ನ
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀವಿ. ಎವಿಡೆನ್ಸ್ ನಮ್ಮ ಎವಿಡೆನ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ನಕ್ಷೆ ಅನುಮೋದನೆ ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ? ಮಾಡಿದ್ದಾರೆ ಏನ್ರಿ? ಅಪ್ರೂವ್ಡ್ ಸ್ಕೆಚ್. ಮತ್ತೆ ನೀವು ಏನು ತಯಾರಾಗಿದೆ ಬಂದ ಆರ್ಗ್ಯುಮೆಂಟ್ ಯಾಕೆ ಬರ್ತೀರಿ? ಅದು ಬೇರೆ ರೀ. ಎಲ್ಲ ತಿಪ್ಪೆ ಸಾರಿಸುವ ಆರ್ಗ್ಯುಮೆಂಟ್ಗಳು ಮಾಡಬೇಡ್ರಿ. ಬೇಸಿಕಲಿ ಪೆಟಿಷನ್ ಸರಿ ಓದ್ಲಿಲ್ಲ ನೀವು. ನಿಮ್ಮದ ಪೆಟಿಷನ್ ನೀವು ಓದ್ಲಿಲ್ಲ. ನಿಮ್ಮದ ಕೇಸ ನೀವು ತಯಾರಾಗಿ ಬರಲಿಲ್ಲ. ಕೋರ್ಟ್ ತೋರಿಸೋ ಇನ್ಕ್ಲಿನೇಷನ್ ಅನ್ನ ಸೂಕ್ತವಾಗಿ ಬಳಸ್ಕೊಳ್ಳಿಕ್ಕೆ ವಕೀಲರುಗಳು ತಯಾರಿಲ್ಲ. ಹೊರಗಡೆಗೆ ಹೋಗಿ ಜಡ್ಜಿಗೆ ಬುದ್ಧಿ ಇಲ್ಲ, ಅವ್ರಿಗೆ ತಲೆ ಇಲ್ಲ, ಮತ್ತೊಂದಿಲ್ಲ ಅಂತೀರಿ. ನೀವು ಸರಿ ತಯಾರಾಗಿ ಬನ್ನಿ. ಇಬ್ರು ವಕೀಲರುಗಳು ನೀವು ಓದ್ಕೊಂಡು ಬರಲ್ಲ. ಹೋಯ್ತ್ರಿ, ಆ ಕಾಲ ಹೋಯ್ತು. ಸಿನ್ಸಿಯರ್, ಆನೆಸ್ಟ್, ಸೀರಿಯಸ್ ಪ್ರಾಕ್ಟೀಸ್ ಅಂತ ಹೋಯ್ತು. ಈಗೆಲ್ಲ ಈಸಿ, ಏನೋ ಒಂದ್ ಹೇಳೋದು, ಏನೋ ಮಾಡೋದು. ಎಕನಾಮಿಕಲಿ ವೀಕರ್ ಸೆಕ್ಷನ್, ಡೌನ್ ಟ್ರಾಡನ್, ಇನ್ನೊಂದೇನೋ ಹೇಳೋದು, ಮತ್ತೊಂದು ಮಾಡೋದು, ಹೋ ಅನ್ನೋದು, ಒಂದು ಆರ್ಡರ್ ಕೊಡ್ರಿ ಇನ್ನೊಂದು. ಆ ಗತಿಗೆ ಬಂದಿದೆ. ಏನ್ ಬರ್ದಿದ್ದೀರಿ? ಬರ್ದಿದ್ದನ್ನು ಗೊತ್ತಿರಲ್ಲ. ಬರ್ದಿದ್ದನ್ನು ಓದ್ರಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ ಬೇರೆದೇ ಓದೋದು, ಪ್ರಶ್ನೆ ಕೇಳಿದ್ರೆ ಬೇರೆದೇ ಉತ್ತರ ಹೇಳೋದು. ಕೂತ್ಕೊಳ್ಳಿ. No further submission. I have heard enough. ಕೂತ್ಕೊಳ್ಳಿ. Absolutely not. Don't interfere while the order is being dictated. The present petitioner has challenged the rejection of or IA number 18 filed under Order 26 Rule 9 read with section 151 CPC in OS number 7595 of 2016 by the court of so and so Brevity Trial Court, where she had sought for appointment of a commissioner for local inspection. To conduct local inspection of suit schedule A and B properties and to submit his report. Full point.
is not in dispute that the present petitioner has instituted a suit against the present respondents, arraigning them as defendants number 1 to 3 in the said OS number 7595 of 2016 for the relief of permanent injunction and mandatory injunction, alleging that the defendant, whose property is just after the common drainage adjacent to her property on the western side, have, without obtaining any approved plan and without complying the requirement of law, or putting up an illegal construction in multi-flow, and in the process have encroached the adjacent drainage, a portion of the adjacent drainage, and at the upper floor level have encroached the property of the plaintiff by extending the sajja considerably, thus coming upon the property of the plaintiff. With this, the plaintiff have prayed for a permanent injunction restraining the defendants from interfering in their alleged peaceful possession of suit schedule A property, and for a mandatory injunction seeking a direction to defendants to remove the alleged encroached open sky area of a particular measurement shown in the plan. In response to the summons, the defendants appearing through their counsels have filed their written statement where, though they have given the description of their property with a schedule attaching to the written statement, with a schedule shown in the written statement, but admittedly the boundary of the said schedule tallies with the suit schedule B property shown in the plan. However, the defendant expressly denied that they have in any manner encroached the property of the plaintiff and causing any obstruction for the alleged peaceful possession of the property, the suit schedule property A by the plaintiff. Next line, the plaintiff at a later stage in the suit, filed the above said IA number 18 seeking the appointment of commission, IA number 18 under order 26 rule 9, read with section 151 CPC for the appointment of commissioner for local inspection. The said application was vehemently opposed by the defendants who filed their statement of objection to the same, vehemently opposed by the defendants. Both the parties have reiterated the summary of their pleadings in the IA and statement of objection to the OO. After hearing both sides, the learned judge of the trial court, opining that appointing the commissioner would amount in collection of evidence, has rejected the said IA under his order dated 19/1/2019. Agreed by the same, the plaintiff in the trial court has preferred this petition. Learned counsel for the petitioner in his argument reiterated the summary of his application and contended that for the alleged encroachment of the property and construction of a building in violation of the law can only be established by appointing a commissioner, but not otherwise, since no documents are available to prove the same. Per contra, learned counsel for He further submits that the property of the plaintiff and defendant is bifurcated with a drainage in between. However, the defendants have encroached the said drainage also by erecting a pillar on that drainage area and extended their construction, encroaching the open sky area of the plaintiff's property. Per contra, learned counsel for the respondents in his argument contended that the defendant's property has never been adjacent to the property of the plaintiff, which is described in Plaint Schedule A. He further, while drawing the attention of this court to some portion of the cross-examination of PW1 and PW2, he further contended that neither of the witnesses are aware of the description of the defendant's property, and they have clearly stated that around the plaintiff property, there exists no property of the defendant. Under the said circumstance, when the defendant's property is not at all adjacent to the plaintiff's property, the question of alleged encroachment does not arise at all. With this, he submitted that the plaintiff is abusing the due process of law. As such, the trial court has rightly rejected the application filed by the plaintiff, rejected IA number 18 filed by the plaintiff. Para. Along with the petition, the petitioner has produced the copies of the client written statement, IA number 18, so to have been filed by the plaintiff, the impugned order, and few photographs. The learned counsel for the respondent also placed for perusal by the court and return, for perusal and return by this court of the evidence of PW1 and PW2, highlighting a couple of sentences in the cross-examination of those two witnesses. Next one. Perusal of the material and placed before the court and submission made by the learned counsel from both sides shows that admittedly the plaintiff's contention is that the defendants are her neighbors. However, the property belonging to both of them are intervened by a drainage. The very first contention of the learned counsel for the respondent that the plaintiff has never been an adjoining property, an adjacent property owner of the defendant's property, though prima facie proves to be correct when seen the evidence of PW1 in her cross, evidence of PW1, the evidence of the plaintiff as PW1, and evidence of her husband as PW2 in their cross-examination. No doubt, PW1 in her cross-examination has stated that she is unable to tell as to in which direction the property of the defendant lies to her property. She admitted the suggestion as true that at the adjacent of the Surchalu property, the defendant's property does not lie. However, it cannot be ignored of her very next statement in the very same cross-examination that she has voluntarily stated that, however, the construction, however, the property of the defendant has encroached about 3 feet upon the plaintiff property. Similarly, PW2 also in his cross-examination, though has stated that on no side of the plaintiff property, the first defendant's property exists. However, he has given the description of the boundary showing the existence of a drainage bracket Charandi on the western portion of his property. The very contention of the plaintiff in their pleading, more particularly in paragraph number 4 of the plaint is that in between the property of the plaintiff and the defendants, there is a 3.5 feet width drainage. In the A schedule property to the plaint, which is shown to be the property of the plaintiff, the western boundary is shown as drainage bracket Charandi. Similarly, in the B schedule property to the same plaint, which says that it belongs to the defendants, the eastern boundary is shown as a drainage bracket Charandi. Even in the written statement filed by the defendants, they have given the boundary of their property, wherein also the defendants have shown the boundary on the eastern side as a drainage bracket Charandi. Thus, the very description of the boundaries given by the parties itself go to show that between the plaintiffs and the defendants' property, there is a drainage. The contention of the plaintiff is that the defendants have encroached the said drainage by erecting the pillars in the said drainage and putting up the construction, and also have extended sajja of their property, encroaching the open sky area of the plaintiff's property. Thus, for such alleged encroachment made, if any, by the defendant, it is not necessary that the property of the plaintiff and the defendant must be attached with each other. However, the alleged encroachment of the drainage and the alleged encroachment of the open sky area above the property of the plaintiff by the defendants has to be proved by the plaintiff on her own by leading cogent evidence in the trial court. Thus, the argument of the learned counsel for the respondent that in view of the fact that defendant's property is not adjacent property attached to the property of the plaintiff, has got no possibility of the alleged encroachment is not acceptable. Next line, admittedly, but as submitted by both sides, the approved plan, if any, with respect to the alleged construction by the defendant has not been produced by the trial court by either side. The learned counsel for the respondent, though submits that
such kind of getting any approval of the plan by any competent authority is not required under the law. However, he could not able to convince the court on the said point. Still, the said point may have to be considered by the trial court at the appropriate time during the course of the argument. But the fact remains that with respect to the alleged construction, the photographs of which the petitioner has produced at annexures E, F, and G no sanctioned plan is said to have been produced before the court, before the trial court. Under the above circumstance, when the property of the parties herein are said to be situated on the side by side, however, bifurcated with a drainage, and the very contention of the plaintiff throughout her plaint is that the said drainage itself is the said drainage which was of a narrow width of hardly 3.5 feet is also said to be encroached by the defendant, and a construction is alleged to have been put encroaching the drainage and encroaching the open sky area of the plaintiff's property. The circumstance of the case shows that no documents in that regard can be secured or procured by the plaintiff except a local investigation by a commission. The plaintiff has further stated that her attempt to draw the action from the part of the BBMP by giving them several complaints also yielded no result or no action from their side. Under the above circumstance, the local inspection conducted by the commissioner and his report cannot be construed as collection of evidence by either of the party. However, the trial court, even after noticing that the property of the plaintiff and the defendant are said to be described showing a drainage as a common mark between the property of both of them, has erroneously held that the property of the defendant does not exist on the side of the plaintiff's property. Further, it even proceeded to make an observation that the very suit of the plaintiff itself is not maintainable in law. Thus, at a very premature stage, when the trial is said to be still going on, before it, the trial court has come to a final conclusion, even regarding the alleged maintainability of the suit. Hence, the said observation made by the trial court that the appointing of court commissioner would lead to collection of the evidence, since as now found to be incorrect, and under the present facts and circumstances of the case, when there are no alternative but for appointing a commissioner for local inspection, the same cannot be construed as collection of evidence. The impugned order deserves to be set aside, and IA 18
filed by the plaintiff in the trial court deserves to be allowed. Accordingly, I proceed to pass the following order. The writ petition stands allowed. The order dated 19/1/2019 passed by so and so on IA number 18 in OS number so and so, which is at annexure K to this writ petition, stands set aside. Said IA number 18 filed by the plaintiff in OS number 7595 of 2016 stands allowed. The trial court to proceed further in the matter in accordance with the law.
Permitted to pay.
That's what my last sentence is. The trial court is directed to proceed further in accordance with law. The trial court would direct him to file a memo of instruction, for which you to have an opportunity to file your instruction. That is several of the aspects where how a trial is required to be conducted in the original suit, probably in several of the matters that is not being properly followed, even in this case also. So that is the reason why I have given the instruction to the trial court to proceed in accordance with law. Otherwise, at the time of filing the commissioner application, if they say what commissioner is required to do, that would have saved a lot of time. Bad luck, the learned counsel is not clearly aware about his case also, about the evidence. So there will be 230. 239. ಅದು ಬಿಟ್ಟು ಬೇರೆ ಸ್ಟೋರಿ ಇದೆ. 213 ಬಿಟ್ಟು ಬೇರೆ ಇದೆ. ಒಂದ್ಸತಿ ಕೂರಿಸಿ ಅದನ್ನು.
Passed over matters. Serial number 4. Sachin Ara.
Called again, none of their pass over. Race next.
Serial number 7.
Same order. Next.
Serial number 8.
On cost. Called again in the second round. Learned counsel for the petitioner who was absent in the first round is physically present now and prays for today's accommodation to comply of his objection. Considering the fact that despite granting 4 opportunities, the petitioner has not complied the sole of his objection, which is trivial in its nature, and also has remained absent when the matter was called in the first round this morning. The granting of any further time, even as a last chance, would be only on cost. Accordingly, imposing a cost of ₹500 payable by the petitioner to the Legal Services Committee of this court within 2 days from today, and filing complaints memo, etc., as a final last opportunity. 1 week time is granted to comply of his objection. Yes.
Serial number 9. S. Naveen Kumar.
Called again, none appear also.
Serial number 15. Serial number 15. Jagdish HT.
Called again, none appear also.
Serial number 18.
Sorry, my lord. 22/2023. This honorable court was pleased to issue notice as well as permitted me to take out handsome as advocate very the trial court, my lord, to ensure service the respondents that I have taken steps, my lord,
ಅಲ್ರಿ ನಿಮಗ್ ಬೈ ಹ್ಯಾಂಡ್ ಆರ್ಡರ್ ಆಗಿರ್ಲಿಲ್ವೇನ್ರಿ? ಅದ್ರ ಬಗ್ಗೆ ಏನು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಲಿಲ್ಲ ನೀವು ಬೆಳಗ್ಗೆ. ಏನ್ ಮಾಡಿದ್ರಿ ಅದ್ರಲ್ಲಿ? ಏನ್ ಮಾಡಿದ್ರಿ ಈಗ? ಅದು ತಗೊಳ್ಳಿಲ್ಲ, ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತಗೊಳ್ಳಿಲ್ಲ. ನೋಡ್ರಿ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಪದೇ ಪದೇ ಹೇಳಿದೆ, ಸೂಟ್ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು ಅಂತ ಹೇಳಿ ಕೂಡಲೇ ವಕೀಲ ರಿಟೈರ್ ಅಂತ ಆಗಲ್ಲ. ಒಂದ್ ಬ್ರೆತ್ ನಲ್ಲಿ ನೀವೇ ಹೇಳ್ತೀರಿ, ಎನಿ ಕಂಟಿನ್ಯೂಯೇಷನ್ ಆಫ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ ಇನ್ ದ ಅಪ್ಪರ್ ಕೋರ್ಟ್ ಇಸ್ ದ ಕಂಟಿನ್ಯೂಯೇಷನ್ ಆಫ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಇನ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಂತ. ಅದನ್ನು ನೀವೇ ಹೇಳ್ತೀರಿ. ಸೂಟ್ ಇಸ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಅನ್ನೋದು ನೀವೇ ಹೇಳ್ತೀರಿ. ನೀವು ವಕೀಲರುಗಳು ನೋಡಿ, ನಿಮಗೆ ಅನುಕೂಲ ಆಗಂತ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಮಾಡಿದ್ರೆ ಸಿದ್ಧಾಗಿಸ್ತಾರೆ. ನಿಮಗೆ ಯಾವ್ದು ಅನುಕೂಲವೋ ಅದಷ್ಟನ್ನೇ ಮಾಡ್ತೀರೇ ಹೊರತು ಕರೆಕ್ಟ್ ಪೊಸಿಷನ್ ಆಫ್ ಲಾ ಹೇಳ್ರಿ ಅಂದ್ರೆ ಹೇಳಲ್ಲ. ಅದನ್ನ ಕೋರ್ಟ್ ಬೇಕಾದ್ರೆ ಹುಡುಕೊಳ್ಬೇಕು. ಮುಂಚೆ ಹಿಂಗಿರ್ಲಿಲ್ಲ ಪ್ರಾಕ್ಟೀಸ್. ಇದೇ ಬಾರ್ನಲ್ಲಿ ಇದ್ದಾರೆ ಸ್ಟಾರ್ವರ್ಡ್ಸ್ ವಕೀಲರುಗಳು. ನಾನು ಅಂಥವ್ರ ಹತ್ರನೇ ಜೂನಿಯರ್ ಆಗಿ ಕೆಲಸ ಕಲ್ತಿದ್ದು. ಅವಾಗ ಕೇಸ್ ಏನೇ ಇರಲಿ, ಫ್ಯಾಕ್ಟ್ ಏನೇ ಇರಲಿ, ಕೋರ್ಟ್ನಲ್ಲಿ ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾ ವಾಟ್ ಈಸ್ ಲಾ ಅನ್ನೋದನ್ನ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ತಾ ಇದ್ರು. ಲಾ ಅನ್ನೋದನ್ನ ಹೇಳಿ, ಇವ್ರದ್ದು ಫ್ಯಾಕ್ಟ್ ಏನಂತ ಹೇಳಿ, ಸ್ವಾಮಿ ಆ ಲಾನ ನಮ್ಮ ಫ್ಯಾಕ್ಟಿನಲ್ಲಿ ನಾವು ಈ ರೀತಿನೂ ಓದ್ಕೊಳ್ಬಹುದು, ಅಥವಾ ಆ ಲಾ ಹೀಗಿದೆ, ಈ ಫ್ಯಾಕ್ಟಿನಲ್ಲಿ ಆ ಲಾನ ಕಂಪ್ಲೇ ಆಗ್ಲಿಲ್ಲ, ಅಷ್ಟು ಫೇರ್ ಆಗಿ ಇರ್ತಿತ್ತು. ನೋಡಿ, ಸುಂದರಸ್ವಾಮಿ ಅವ್ರ ಸಬ್ಮಿಷನ್, ಜಯರಾಮ್ ಅವ್ರ ಸಬ್ಮಿಷನ್, ಜನಾರ್ದನ್ ಅವ್ರ ಸಬ್ಮಿಷನ್, ತಾರಕ್ರಾಮ್ ಅವ್ರ ಸಬ್ಮಿಷನ್, ಒಬ್ಬರದ ಇಬ್ಬರದ. ಜಡ್ಜ್ ಏನಾರು ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಜಡ್ಜನೇ ಬೈಯ ವಕೀಲರುಗಳು ಇದ್ರು. ಈಗ ಏನಿಲ್ಲ, ನೀವು ಓದ್ಕೊಂಡ್ಬರ್ಬೇಡ್ರಿ, ನಾವು ಓದ್ಕೊಂಡ್ ಬರಲ್ಲ. ಏನು ಒಂದು ಹೇಳ್ತೀವಿ, ಸ್ಟೇ ಕೊಡ್ರಿ, ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ರಿ ಕೊಡ್ರಿ, ಆಮೇಲೆ 4 ವರ್ಷ ನೀವು ಇರ್ರಿ, ನಾವು ಸುಮ್ಮನೆ ಇರ್ತೀವಿ, ನೋಡೋಣಂತೆ. Called again in the second round, learned counsel for the petitioner who is physically present submits that now he has noticed that under the order dated 22/2/2023, the court had permitted the petitioner to serve the respondents or their learned counsel before the trial court by way of hand summons. Though the suit is said to be disposed of, however, no attempt was made to serve the copy through the learned counsel appearing for the present respondent in the trial court. He prays for 2 weeks' time to do needful and to file a complaints memo along with acknowledgement, if any. The time as prayed is granted. In the meantime, the petitioner is also take fresh steps to ensure the service of notice upon unserved respondents through normal course.
Serial number 19, Yeshubaba, Mr.
None appear. Called again, none appear for.
Serial number 24. Serial number 24, Shinmukappa.
Called again, none appear. Pass over ಅದನ್ನು ಮಧ್ಯಾಹ್ನ ಅಂದಿದ್ದು.
Serial number 25. 25, Bhaskar Hegde, CK.
Called again, none appear. Pass over.
Serial number 26, Ramesh Hechi.
Called again, none appear. Pass over.
Serial number 27, LS Venkatakrishna.
Called again, none appear. In spite of there being an order for issuance of notice as long back as on 17/11/2023, but till date the petitioner has not taken steps. As such, making it clear that in case if the steps are not taken within 2 days from today, the court would proceed to pass appropriate order, including dismissal of the petition. for not taking steps, the matter stands adjourned to 29/1. Within a day, within 2 days, better. 29/1. Yes.
28/7 PT.
Called again. Then appear for the petitioner either physically or through video conference. Perusal of the order sheet would go to show that in this matter, Rosalind back as on 7/8/2023, there was an order for issuance of emergent notice to the respondent. In spite of granting such an order of emergent notice, the petitioner, who is enjoying the interim order in the matter, has not taken step. Thereafter, the matter came up on 17/11/2023, on which day the learned counsel for the petitioner had remained absent. Still, the court granted a week's time for the petitioner to take fresh steps to ensure the service of emergent notice upon unserved respondent number 1 and 2. In spite of the same, the petitioner has not taken steps for service of notice to respondent number 1 and 2. Under the above circumstance, it has to be inferred that the petitioner is not inclined to prosecute the petition. As such, the writ petition stands dismissed for not taking steps as well as for non-prosecution. Don't put it ವಾಪಸ್ ಕೊಡ್ರಿ ಅವ್ರದ್ದು evidence. No, that is your property. The court itself should have given to you, not waiting for you to ask for it. Court officer did not do. They should say sorry, not you.
230 division bench matters, pronouncement of judgment, till the one SPP.
May I proceed, sir?
Please, please.
Appeal filed by the appellant state is hereby partly allowed. The judgment of trial court on the file of first additional district and session judge is hereby set aside. Accused is convicted for the offence under section 302 of IPC. The acquittal judgment passed by the trial court for the offence under section 498A and 304B of IPC stands confirmed. To hear on quantum of sentence. Yes, Vinay.
ಮರ್ಡರ್ ಮಾಡೋದ್ರಲ್ಲಿ
Murder ಮಾಡೋದ್ರಲ್ಲಿ
ಮುಗಿಸ್ತೇನ್ರಿ. ಒಳ್ಳೆ ಕಥೆ ಆಯ್ತಲ್ಲ.
ನಿಮ್ದು ಸ್ಟೇಟ್
ನಾಳೆ ಅವ್ರಿನ್ನೂ ಮುಗಿಸ್ಲಿಲ್ಲ.
ಅವ್ರು ಹೇಳ್ಬೇಕಿನ್ನ ಫಸ್ಟ್ ಅಫೆಂಡರು.
Look at the proximity of the duration between her marriage and the death. Hardly within 3 months. Please.
Heard states on quantum of sentence. The additional SPP for appellant state submits that accused has committed heinous offence of murdering his wife Asha by pouring kerosene and lit fire to her, and she died due to burn injuries, and her suffering continued for more than 2 months has been proved by the prosecution. Next part. Per contra, learned amicus query for respondent accused submits that accused is the first offender and has no any criminal antecedents. And the incident in question has occurred in 2010. Further, the entire family members are depending on his income. Therefore, pray for taking lenient view. Next. It is the sentencing policy that sentence order must be proportionate to the full offence against the accused. Point. The imposition of sentence shall be neither exorbitant nor flea bite sentence. Point. In the present case, accused is found guilty for the offence punishable under section 302 of IPC. Looking to the facts and circumstances of the case, coupled with the allegations against accused, we proceed to pass the following. Nandi alias Nandisha, son of Umara, is convicted for the offence under section 302 of IPC and sentenced to undergo imprisonment for life and sentenced to pay a fine of 25,000. In default of payment of fine, accused shall undergo additional imprisonment for 1 year for the offence under section 302 of IPC. Accused is entitled for the benefit of set off under having undergone by him in judicial custody, if any, in the matter. Next, on realization of fine amount, the entire fine amount is ordered to be paid to PW1 Veena, mother of deceased Asha. Next, accused shall surrender before sessions court within 30 days from today to serve the sentence. Next, accused is entitled free copy of this judgment immediately. The services rendered by the learned amicus query for the respondent is placed on record, and honorarium is fixed as ₹5,000 payable by the registry. Arranged to transmit the reports immediately. To approach DLSA. DLSA ಕೊಡಗು ಮಡಿಕೇರಿ ಅಲ್ರಿ ಕೊಡಗು ಮಡಿಕೇರಿ ಫಾರ್ ಕಾಂಪೆನ್ಸೇಷನ್. Criminal appeal filed by the appellant state is hereby allowed. The judgment of trial court is here set aside for reference under section 302 and 201 of IPC. To hear on sentence are daughter is our minor daughter. Still she is minor. SSLC. And he is an auto driver. He's the only member in the survey. No other friend in the
Driver.
Yes, sir. He is suffering from cancer and after doing work, auto driving work, taking care of minor daughter.
He is suffering from cancer.
Cancer. Yeah, he took treatment from Kidwai Hospital, Bangalore. So now he had about 56 years. 36 2022, he took treatment in Kidwai Hospital. Now also he's going to in that treatment also he's doing the auto driving. And no other members in the family. It's a only one member in that family. The rest is the Lord.
To show that it was a suicide.
We received the entire investigation and then acted as if nothing has been. And also there is intention and
The offense itself imposes the prescribed punishment. We cannot record less the sentence which has been stated. Heard both sides on quantum of sentence. Learned additional SPP or appellant state submit that accused has mercilessly committed murder of his helpless wife in a place where there was none to rescue her. And it was only accused and Mrs. Antoniamma were there at the place of incident during the night hours and as such is not entitled for any leniency with respect to the offences proved against him. And it is further submitted that accused to screen the offence under section 302 of IPC has projected that as if it is a case of suicide. Adadmele does not entitle for any leniency. For contra, learned counsel for respondent submit that accused is a driver by profession and running auto rickshaw. Further, his daughter is studying in 10th standard and she is dependent on the income of accused. And also he is required to take care of his daughter, therefore prayed for taking a lenient view. Next one. It is a sentencing policy that the sentence order must be proportionate to the true offence against the accused. The imposition of sentence shall be neither exorbitant nor flee by sentence. In the present case, accused is found guilty for the offence punishable under section 302 and 201 of IPC. The offence under section 302 of IPC is punishable with death or imprisonment of life and shall also be liable for fine. The offence under section 201 of IPC is punishable with imprisonment for life or with imprisonment which may extend to 10 years. One shall be punished with imprisonment with either description for a term which may extend to 3 years and shall also be liable to fine. It is not a rarest of rare case to impose death penalty. And looking to the facts and circumstances of the case coupled with the allegations against accused, we proceed to post the following. Accused is sentenced to undergo imprisonment for life and pay a fine of 10,000 and in default of payment of fine, shall undergo imprisonment for 6 months for the offence under section 302 of IPC. Next term. Accused as referred above is sentenced to undergo imprisonment for 10 years and pay a fine of 5,000 and in default of payment of fine to undergo additional simple imprisonment for 3 months for the offence under section 201 of IPC. Next term. The sentence of imprisonment as ordered above are ordered to run concurrently. Next term. Accused is entitled for the benefit of set off under section 428 of CRPC for the period having undergone by him in judicial custody, if any, in the matter. Next term. On realization of fine amount, the entire fine amount is ordered to be paid to brother of victim PW1 Charlie. Next, accused shall surrender before sessions court within 30 days from the today to serve the sentence. Next, accused is entitled for free copy of the judgment, registered to transmit the records immediately for compliance.
Cancer. Yeah. Contention is only accused is a cancer patient under treatment.
Cancer patient at the Bandilwa. Learned counsel for the accused submits that the accused is an auto driver by profession and suffering from cancer and he is under treatment of on that matter.
Serial number 3, SPP AR Vivek, correspondent.
Criminal appeal filed by the state is hereby dismissed as devoid of merits. Thank you very much for the members of the bar having cooperated. Even my during illness also. Thank you.
Simultaneously, sorry for the delay.
Sorry for the delay also. Because of my health, I could not complete it early.
Past two matters, serial number 4, Sachin RR.
Called again in the third round in the afternoon. Land counsel for the petitioner neither present physically nor through video conference. The result of the order sheet would go to show that in this writ petition of the year 2021, in spite of granting sufficient opportunities of not less than 3 times, the appellant has not complied with office subsections, which are 7 in number but are trivial in their nature, hardly requiring considerable time to complete. Till the appellant, the office objections include the objections like not mentioning the provision of law, not carrying out correction in the prayer column, not stating correctly about the annexure in the affidavit, making single pagination, etc. Even to comply those trivial office objections, the petitioner has not shown any interest in spite of getting sufficient opportunities. Hence, it has to be informed that the appellant is not interested in prosecuting the matter. Appellant or petitioner not interested in prosecuting the matter. Accordingly, the petition stands dismissed for non-prosecution as well for non-compliance of office objection. Yes.
Serial number 7, Maruti S. Irapari DM, correspondent, Kevetu.
ಈಗಿಂದ ಫಾರ್ಮೆಟ್ ಇಟ್ಕೊಳ್ಳಿ 4 times percentage trivial office objection 2 in number. Paying deficit court fee up to 100 and filing a typed copy of manuscript. ಮುಂದಿಂದೆಲ್ಲ it is non-prosecution non-compliance.
Serial number 9, S. Naveen Kumar.
Similar order. 4 times not complete trivial 4 office objection. Including correction to be carried out in the prayer, filing of the typed copy of manuscript, stitching the annexures as readable, etc. Dismiss non-prosecution, non-compliance.
Then past two matters, serial number 11, G. Balakrishna Shastri.
Called again in the afternoon, the counsel for the petitioner is physically present and submits that office objections are complied. Registry also endorsed to that effect. Registry to proceed further in the matter.
Serial number 12, Ganapati Subraya.
Petitions complied and then possible. Called again in the afternoon, none appear in the matter. The registry has endorsed that after paying the cost, the petitioner has completed the office objection.
I have complied the
Okay, none appear fully. Counsel for the petitioner present and submits needful done. Registry also endorsed to that effect. Registry to proceed further in the matter.
Serial number 15. 15, Jagdish HT.
Called again in the afternoon in the third round. With the last, none appear with the sixth time opportunity. Only two office objections, which are very trivial, like paying the court fee and filing. Objection of RA. Same order, dismiss, non-complaints, non-prosecution.
Serial number 19, Yeshu Baba R. Mishra.
Called again in the afternoon, learned counsel for the petitioner who is physically present files a memo seeking dismissal of this writ petition as having become infectious. In view of the memo supporting submission, the petition stands dismissed as having become infectious.
Serial number 24, Shanmukappa.
Called again in the afternoon, the third round, learned counsel for the petitioner neither present physically nor through video conference. List the matter on 29/1/2024. It is made clear that non-appearance of the learned counsel for the petitioner and not proceeding further in the matter on the said day would lead this court to pass appropriate order, including dismissal of the petition for non-complaint, for dismissal of the petition for not taking step as well as for non-prosecution.
Serial number 25, Bhaskar Hegde.
Called again in the third round in the afternoon. Learned counsel for the petitioner neither present physically nor through video conference. No reasons are forthcoming for his non-appearance. Perusal of the order sheet would go to show that in this petition, the learned counsel has remained absent continuously on 30/10/2023, when the matter was called in 2 rounds. Matter was called in 3 rounds. And on 17/11/2023 also. Even today also, when the matter was called in 2 rounds in the morning session, the learned counsel for the petitioner has remained absent. Hence, it can be inferred that the petitioner is not interested in prosecuting the matter. He has not even tried the process and taken steps to issue notice to the respondent, though ordered on 17/11/2023. For the above reasons, the petition stands dismissal for non-taking step as well as for non-prosecution.
Cell number 26, Ramesh H.
Called again in the afternoon, learned counsel for the petitioner is physically present and submits the needful done registry to verify and proceed further. Thank you.